This is a huge deal. As to the Third Circuit decision, Mark, the reality is this is kind of like a paint-by-numbers decision that I think the Supreme Court's going to follow, not because the Third Circuit is teaching the Supreme Court, but because the Third Circuit is doing what the Supreme Court has already said, and now the Supreme Court's going to slam the door on these anti-gun courts that have been playing games with the proper interpretation of the Second Amendment. That ain't going to happen again.
Now, this was a Biden appointee that wrote this incredible 120-some page majority opinion here in a 10-5 decision in a complete en banc when the entire circuit heard this. This appears to be a slam dunk, Mark. Is the Supreme Court going to look at this as the roadmap? And you just alluded to it. I'm going to guess that that's, did the Third Circuit do this intentionally to school the Supreme Court? Let's put that together for listeners and viewers.
I don't think the Third Circuit was trying to educate the Supreme Court, because I think everyone understands the Supreme Court knows what they're going to do. Precedents have been clear. The lower courts have been playing games, pretending that they don't understand Supreme Court precedent, but everyone understands that those were exactly games. What really happened here was that the U.S. Court of Appeals for the Seventh Circuit in Chicago with Frank Easterbrook basically said that we're going to uphold the Illinois law with a long opinion, and the Third Circuit says, well, we're going to respond. So essentially, the way to view this is the Third Circuit decision in Cheeseman is like an amicus brief in favor of the Second Amendment. And yes, the Third Circuit has a lot of judges that are on there that are very respected. And by the way, I think there's probably 3 judges on the Third Circuit that could potentially be elevated to the U.S. Supreme Court. So to the extent you want to build up your Second Amendment bona fides, Mark, as a lower court judge, it's a perfect opportunity to do so, to come out, A, on the right side of the Second Amendment, and B, on the right side of where the Supreme Court's likely going to rule in June of 2027.
All right, I'm going to ask you a question about Amy Coney Barrett. I haven't had a chance to ask you this yet, but I put out a theory. When she wrote the concurring opinion in the Wolford decision, I thought it was very odd because she didn't step outside anything that Alito had written. She essentially spent 34 pages agreeing with everything Alito ruled in that majority opinion. Well, hindsight is 20/20. She knew before we did, when she wrote that concurrence, that she was going to catch a lot of flack in the voting rights decision. She also knew that SCOTUS had already granted cert behind the scenes, behind closed doors, that we were not aware of yet. Was she signaling her 2A chops to us, knowing that this decision was going to come out? She was going to be attacked, deciding with the liberals, her and Roberts, and this was her way of showing us her 2A chops and not to fear her in the upcoming 2 cases that they granted cert in? Is that possible?
I don't think we have to worry about Amy Coney Barrett at all. I think there's a lot of people online that, express concerns about her, but she is a rock-solid conservative. I mean, if you want to look at the handful of cases that, she's technically come on the other side of Alito and Thomas, they were very close cases in terms of constitutionalism. Like the birthright citizenship case is a very close case where you have originalist arguments going both ways. But at the end of the day, keep in mind that these threats to Justice Barrett's life, most of which occurred after the Dobbs decision was leaked, and she stood firm and issued the Dobbs decision that knocked out Roe v. Wade, and stood firm and issued the Bruin decision. So no, I'm not worried about Justice Barrett or Justice Roberts on the AR-15 question, and I don't think we need to worry about her, frankly, at all on all the other big questions. I mean, if you look at her record, it's a phenomenal record. Again, there's a couple cases you can sort of, pick at, but I don't think, as to why she wrote that concurrence, I think there is a little back and forth between Justice Barrett and Justice Brown Jackson. And if you look at footnote number 1 of Justice Barrett's concurrence in Wolford versus Lopez, it's an extremely important footnote, not just for the AR-15 case, but for all aspects of Second Amendment jurisprudence, Mark. Specifically, she says that you're not allowed to smuggle history or historical traditions into the plain text analysis, which is what lower court after lower court after lower court have been doing in an attempt to knock out Second Amendment rights claims by the Second Amendment community. And Justice Barrett, in that footnote, made clear that should never, ever occur again. She said that was not the way to do it in the past, it's not the way to do it today, and it's not the way to interpret the Second Amendment moving forward. That is very good for us. I think that there's you got to understand, Mark, this court, in terms of the 6 conservatives, is a very smart, very highfalutin, serious theoretical court. They really care about abstract thinking and the ideology of laws and how to understand these things. They're very abstract in their thinking, and they want to get it right. So there's sometimes these sort of ideological, they're not really sort of political versus conservative versus liberal or anything like that. It's just the way to approach interpreting the Constitution. There's sometimes these internal debates between like a Justice Barrett and a Justice Alito, but for most 99% of the time, it doesn't matter. I think Justice Barrett, in her concurrence, was trying to say that she thought that some of the language in the majority opinion was a little too loose for her, and in some ways the Justice Barrett concurrence in Wolford was a more firm Second Amendment argument than the majority. But again, these are very fine details, and I don't think any of this is going to matter to the AR-15 fight. We're going to win this. The only question is going to be is the scope of the victory and the language that finds its way into that opinion in favor of the AR-15 and how broadly it will fall. Will it cover all semi-automatic rifles? I think the answer is going to be yes.
Right.
Will it address any of these so-called scary features? I think the answer is yes. I think they'll say the features don't matter. But again, they are always laying out jurisprudence, because when the Supreme Court issues a decision, we have to live with it, not just for years, but sometimes for decades and generations. So they're very careful to try to get this right. And sometimes that gives rise to debate about the proper language. And I would not fear the AR-15 case. And I certainly would not worry about Justice Barrett. I think the online stuff a lot of it is nonsense.